Okay, I talked to you about a conspiracy against rights under the color of law. Okay, so before you go there, you got to go to deprivation of rights, and this is where it starts. Okay, deprivation of rights starts with your effective assistance, your right to effective assistance to counsel guaranteed to you in the United States Constitution. Remember, any laws repugnant to the Constitution are null and void, can't exist, can't be enforced. Okay. Okay, so we're going to the Illinois Supreme Court of Rules of Professional Conduct. I wanted to use the ABA because the ABA Model Rules of Professional Conduct. That's what it is. It's the Model Rules of Professional Conduct for every state. They can enhance it, make it stronger, give it more teeth, bigger bite. But they can't take from it. That would be in the interest of the bar, not in the public interest. Okay, so let's go to Illinois Supreme Court Rules of Professional Conduct, okay? This is where deprivation of rights starts, because if you get a lawyer, your lawyer should be going over this, because once we get into the preamble, it'll tell you that, in order for anything to proceed forward, you must give informed consent. In order to give informed consent, you need reasonable knowledge to make an informed decision, to give informed consent. And thus, by now, if you're listening to me, you know that reasonable knowledge needs to be the legal knowledge of a legal, learned professional in order to succeed in court. Okay, so these are the legal obligations of all judges and lawyers. They used to say that on top, but okay, let's see. Article, rules, article, rules. Okay, we won't go to the preamble and scope yet. Okay, let's, rule 1.0, terminology, no, competence. Okay, a lawyer must be competent. That's pretty easy, right? I think you understand that, but in case you don't, there it is, alright? It's right there. A lawyer shall provide competent representation to a client. Competent representation requires legal knowledge, skill, thoroughness, and I can't see, that's pretty small. Okay, but so they must be competent, act in a competent manner. Okay, Rule 1.2, scope of representation, allocation of authority between client and lawyer. I've had lawyers switched up on me in court without my consent or knowledge. That's not legal, but they'll do it anyways. Rule 1.3, diligence. They must be diligent. People often argue with me about the quick and speedy trial. It does have its limitations, and if your case isn't heard within 90 days, gone to trial within 90 days, they exceeded your quick and speedy trial right, and the case gets tossed out. Okay, you just don't know that because you haven't looked up a quick and speedy trial. That's all you gotta do. Put in your search bar, quick and speedy trial. I did a video on it. Okay, so diligence. Right there. A lawyer shall act with reasonable diligence and promptness in representing a client. Okay, so that's not so hard to understand, is it? And even below these, it gives comments. It tells you how they should act and shouldn't act. Okay, but diligence. So diligence is required. Communication. All right. Did they communicate this to you? I mean, did they communicate to you that they needed to get informed consent, and that in order to get that informed consent, you needed reasonable knowledge to make an informed decision? That's in the preamble. 1.4, communication. No, they didn't. They didn't communicate that. Fees. Any fees are unreasonable fees. There's nobody told you about this. Okay. 1.6, confidential information. For the most part, they'll keep it from you. People who aren't allowed access to discovery for some obscene reason or another. But it's everybody's job in that courtroom to see to it that you receive discovery. Withholding it from you, it's against the law, but you'll find that out once you go through here. Okay, conflict of interest, that happens a lot. Current client specific rule, conflict of interest. Duties to former clients. Okay, you're going to want to read that because a lot of you may not, you may have resolved your issues with your attorney, but they may have been unsatisfactory. So you'll duties to former clients. Okay, so you're going to want to read that. So like I said, the rules apply in every court, but not every rule applies to every court, depending on what court you're in. So you'll have to pick and choose which ones. Interpretations of conflicts of interest, so you can read that up. Organization as a client with diminished capacity. If any of you had to deal with had family or loved ones with a diminished capacity and had problems in court, taking care of those people, well, you should want to read that. Somebody make a silly accusation, next year, they raid your house, take your, grandma, grandpa, disabled little brother or sister or whoever, without due process. Okay, so this is part of the due process thing. If you don't have effective assistance of counsel, you didn't get a fair trial. If you didn't get a fair trial, due process doesn't exist. Safekeeping property. Okay, I was talking to somebody, what was it, probate court, and somebody in conservatorship, and these people had access to everything, and they drained these people's savings. Okay, but safekeeping property, lawyers, I've read about lawyers doing this, so you're going to want to read this, okay? This is the law on what they're supposed to do. It also tells you about fees and whatever, and just read it, if you had loss of property because of guardianship, whatever, required records, trust accounts. See, people always say I was lucky in court. No, I used to take this stuff with me, copies of it. First time I found it was in 1979. And ever since then, I've been advocating for a due process. Real due process, not just people talking about it. Duties to a prospective client. So if anybody's looking for a lawyer, you should read that. Anybody should looking for a lawyer, needing a lawyer for anything, should be going through all this. This is what makes effective assistance of counsel. You'll understand as I go on. Meritorious claims and contentions. Okay, so that means everything you say has to be substantiated. You can't come to court with thoughts and prayers, hurt feelings. Just because you're mad, you're going to sue somebody? No, you can't do that. You can't do that. You're going to, I've seen people go to jail, and they're locked up for almost a year, 2 years, and he had to prove his innocence. Public defender. It's a public defender. It's all lawyers' job to investigate a case. All cops. It's the detectives. It's but the police department to investigate a case to see if there's probable cause. That's why a lot of people call in for a supervisor for being arrested. Then you go to court. It's almost impossible. Well, Illinois, it's impossible to get a probable cause hearing. Judges get mad, the lawyers get mad. I had a lot of public defenders get mad at me. State's attorney used to laugh, just stand back and laugh. And the judge would always get mad at me. So remember, there always has to be meritorious claims and contentions, all right? And if not, then it's, hearsay. It's frivolous and fraudulent. Basically like a slap suit, but, that's in civil court and criminal court is just not doing it. It's just expediting litigation. So that's another part I was telling you about a quick and speedy trial. It would be diligent to expedite litigation. Okay, so, litigation that a lawyer shall make reasonable efforts to expedite litigation consistent with the interest of the client. And the interest of the client is PDQ, right? You want it quick, fast, in a hurry. So anytime somebody tells you you don't have to a quick and speedy trial, remember it's diligent to expedite litigation, if not, I have to make that a point, in the court, candid towards the tribunal. See, candid towards the tribunal says you can't come in there and not do all this other stuff. So when they break one rule, they break a multitude of rules. And when they violate the rules of professional conduct, the Code of Judicial Conduct is violated just as well. They're intertwined. It's impossible to violate one rule without violating multiple. It's impossible to violate one code without violating multiple. Okay, candid towards the tribunal, fairness to the opposing party and counsel. So everybody's, required, to expedite litigation. So, sometimes I've seen it in civil cases. I help with some people. And their lawyer, I went in there, the lawyer's like, yeah, well, I didn't get this from this. I told the guy, hey, read it. So we started going. So he said, fairness to the opposing party and counsel, wouldn't it be competent to be diligent in expediting that litigation? The lawyer said, what? He says, yeah, I'm reading your job description. And the lawyer got mad and kicked us out. And I had another lawyer, but see, he can't quit like that. So that's when I started talking. Okay, impartiality and decorum of the tribunal. And that doesn't happen, that, so read up on it. Okay? See, a lot of this stuff doesn't happen. It's supposed to happen. This is essentially where reasonable knowledge to make an informed decision, to give informed consent, starts. And they may tell you, hey, this don't mean what you think it means. Don't believe your lying eyes. But use the letter of the law. The letter of the law clearly states everything here must be done. Anything written, any law, any contract, must be abided by word for word to the letter in the spirit of the law, so that we all hear, see, and say the same thing. Pretty simple, right? Lawyer is a witness. Special responsibility of the prosecutor. That's why I wanted to come to the Illinois. They enhanced Rule 3.8. Not much, but it's all the way down here. Oh, man, I wish my vision was better. The duty of public prosecutors to seek justice, not merely to convict. The prosecutor in a criminal case shall refrain from prosecuting a charge a prosecutor knows is not supported by probable cause. So not only is a public defender denying you a probable cause hearing, so is a state's attorney. The state's attorney knows they can't even charge you if they don't have probable cause, but they will anyways. And since your lawyer won't ask for a probable cause hearing and the judge ain't going to mention it, I've only seen one judge on YouTube, and he always insists on having a probable cause hearing, which is a mandate, if you read the law. Okay, so the state's attorney is pursuing a case without probable cause. That's malicious prosecution. They do it all the time. Refrain from prosecuting a charge that the prosecutor knows is not supported by probable cause. Constantly make reasonable efforts to ensure that the accused has been advised of the right and procedure of obtaining counsel and has been given reasonable opportunity to obtain counsel. So that's the only time they can talk to you. They have to let you know that they are, working with the state's attorney's office. I've had a few of them talk to me without telling me that they're from the state's attorney's office. I got arrested. I told the cops I wanted to talk to my attorney. After they beat the hell out of me, they said, "Oh, you want to talk to attorney?" They brought me an attorney. It was the state's attorney. And then she got mad because I was asking who she was. She said, "Are you a public defender?" I said, "I got a lawyer." I gave him my number, and you're not him. So she started asking me questions. I only answered a couple of them, just referring to I didn't know what the cops were talking about. They just broke into the house, guns drawn, and I'm here. So I asked if she was a state's attorney, and if she was, she knew she had no legal right to talk to me. And if she did try to, she had a legal obligation to tell me that I had the right to have an attorney present. To make timely disclosure to the defense of all evidence or information known to the prosecutor that tends to negate the guilt of the accused or mitigate that follow, and in connection with sentencing, disclosure to defense and tribunal on privilege mitigation. Okay, but so you're going to want to read that. Okay, where is it? Down here? No, down here. People are looking for lawyers to help them overturn wrongful convictions. A good lawyer. They got all this exculpatory evidence. And I never talked to them personally, but I used to put this in the comments for them. There it is. G. When a prosecutor knows new, credible, and material evidence creating a reasonable likelihood that a convicted defendant did not commit an offense of which the defendant was convicted of, the prosecutor shall promptly disclose that evidence to an appropriate court or authority, and if the conviction was obtained in the prosecutor's jurisdiction. See, so it doesn't even have to be in their jurisdiction. If the conviction was obtained in the prosecutor's jurisdiction, promptly disclose that evidence to the defendant unless the court authorizes delay, and undertake further reasonable investigation to make reasonable efforts to cause an investigator to determine whether the defendant was convicted of the offense that the defendant did not commit. When the prosecutor knows of clear and convincing evidence established that the prosecutor's conviction was convicted of the offense the defendant did not commit, the prosecutor shall seek to remedy that conviction. Okay, but where's the federal? I think it. Hold on. Oh yeah, here it is. Okay. So have you ever read Brady versus Maryland decision? It's basically based on Rule 3.8. Prosecutor not doing their job. And, but see, even these guys had to remind you. United States Attorney, this is 1935, the U.S. Supreme Court described the duty of a federal prosecutor, and remember, this is for all prosecutors, in the following passage. The United States is a representative not of an ordinary party to controversy, but of a sovereign whose obligation to govern impartially is compelling it, as is the obligation to govern at all, with whose interest, therefore, in a criminal prosecution is not that it shall win a case, but that justice shall be done. As such, he is in particular and very definitive sense that the servant of the law, twofold aim to which is the guilt, shall not escape, and the innocent suffer. He may prosecute with earnestness and vigor indeed. He should do so, but what he may, but while he may strike hard blows, he is not at liberty to strike foul ones. It is much to his duty to refrain from improper methods calculated to produce a wrongful conviction, as it is to use every legitimate means to bring about a just one. You know, I mean, they know. I know. If I know, they know. Okay, but they won't. Okay, so if you're trying to overturn a wrongful conviction and you can't find a lawyer that's going to help you, and you got the sculpatory evidence, hey, prosecutor, it's your job to exonerate me. Let's do this. Okay. Because and then you're gonna want to tell them, hey, look what happened here. My lawyer didn't report the state's attorney for prosecutorial misconduct, the judge for judicial misconduct, or himself for ineffective assistance of counsel. State's attorney didn't report my counsel for ineffective assistance of counsel for judicial misconduct, or themselves for prosecutorial misconduct. The judge didn't abide by the rules of professional conduct and report my lawyer for ineffective assistance of counsel. The prosecutor for prosecutorial misconduct and themselves for judicial misconduct. Reporting misconduct is mandatory in both the rules of professional conduct and the Code of Judicial Conduct. Everybody is guilty of deprivation of rights, thus proving a conspiracy against rights under the color of law. Okay, so that's what you want to tell them when you go there to exonerate you with your exculpatory evidence. Okay, is that pretty easy? You think? Advocates and not adjudicated. I'm sorry, I don't mean to laugh. It's just that it hurts so much seeing so many of you hurting. And so I don't scream, yell, throw stuff, swear. I don't like to swear. It's not part of my persona, but sometimes when I get angry, the words that come out of my mouth. Communication with person represented by client. Dealing with unrepresented person, basically they're not supposed to talk to you unless you have representation, unless you decline your right to that said representation. But who's going to decline their rights, right? It's respect for rights of third-party persons. A lot of you have problems with that. Responsibility of partners, managers, supervisor, lawyers. Responsibility of subordinate lawyers. Like they're supposed to report the higher-ups if they're not doing any of this, but they don't do it. Same thing, responsibilities regarding non-lawyer assistance, professional independence of a lawyer, unauthorized practice of law, restrictions on right to practice. See, there's a lot you can learn. Hold on, I'm getting there. I'm just reporting professional misconduct. Okay. First, let's go to misconduct. Okay. So what does misconduct say? Professional misconduct for a lawyer to violate or attempt to violate the rules of professional conduct, not only assist or infuse another to do so through the acts of another. Okay, so right there, just violating the rule. There's a lot more that you can get them for this misconduct. Okay, violating the letter of the law, violating the rule of law, violating the oath oath of public service as well as the oath he took as a lawyer, and violate all these. Everything carries penalties. Everything carries penalties. Okay, so reporting professional misconduct. Okay, a lawyer who knows and sorry, lawyer. A lawyer knows that another lawyer has committed a violation of Rule 8.4. Rule 8.4 shall inform the appropriate professional authorities. A lawyer who knowingly knows the judge has committed a violation applicable to the rules of judicial conduct and raise a substantial question. Okay, so it's mandatory to report judges and lawyers. Judges, if they violate the rules of professional conduct or the Code of Judicial Conduct, and lawyers, if they violate the rules, the rules of professional conduct. Everybody's supposed to report each other for violating the rules or the codes. Reporting professional misconduct. Failure to report is misconduct. Okay, so that's like a double whammy. So if they violate one law, they say, well, everybody committed misconduct. Reporting misconduct is mandatory. Nobody did that. Thus, another count of misconduct. Okay. But no matter what court you're in, remember Rule 3.8 is only for criminal courts. All these apply to every court. 3.8 is only for criminal court. Don't forget all this other stuff. Special, fairness to the opposing party. Communication concerning the lawyer's service. See, and a lawyer shall not make false, misleading communication about the lawyer or the lawyer's services. Communication is false, misleading if it contains material misrepresentation of fact or law, or omits fact necessary to make the statement considered as a whole, not material misleading. Yeah, I have an issue with a law firm that, because they advertise on TV, and what they advertise isn't true. It's easy to prove, but it's misleading. Legally, that's called disinformation. Lawyers can't, use disinformation. That's illegal. There's penalties for disinformation, okay, for all lawyers and judges. I did a video on that. You can look that up, okay. So that's what I was talking about, advertising, disinformation. There's a lot you can use here if you just go over it and just think about what you're doing and what you're going through. Remember, people, this is the only way you're going to achieve effective assistance. This is the only way you're going to get a fair trial. This is the only way you're going to get due process. Okay, so like I said, it's mandatory for lawyers to report him. So the judge has to report your lawyer and the opposing party for not doing any of this, okay? And then themselves as well as for the violating the Code of Judicial Conduct. Okay. Yeah, when a judge violates the Code of Judicial Conduct, this is where you file it with the inquiry board. And they're not going to do anything. I'm not going to lie to you. I started filing with them back in the 80s. And not just for myself or other people. But, it's some lawyers, they laughed at me. I beat them in a civil case. And I kept throwing the rules and the codes and talking about disinformation and, candidates. Nothing they were suing me for could be proved. And I quite literally proved to them, or tried to prove them in a court, and a conspiracy against rights under the color of law. Everybody worked together to get me this far, which was nothing but legal harassment. It shouldn't have happened in the beginning. It should have never started. And if it did, I didn't have the reasonable information to make an informed decision, to give informed consent. Fair and impartial judiciary, so you're going to come on, seriously? Based upon principle? Them not doing this, remember, it's also ethics violations. So just look up, ethics, where to file ethics complaint for, and then you just put in for whoever it is or wherever they're at. Judge shall maintain the dignity of judicial office and both impropriety and the appearance of impropriety in their professional and personal lives. Seriously, you ever see that happen? They're always showboating. I'm surprised they're not riding around in those mega yachts, so they're not even supposed to give the appearance. In professional as well as personal life. I seen this one judge on YouTube complaining about it. Oh, he only makes $250,000 a year. And all he's got to drive around in is this big old custom RV, I think he said it was. Hanging out with billionaires. Going all different places. People say to you it's a known fact that the U.S. Supreme Court doesn't have a code of conduct. Okay, but that was clearly in the interest of the bar. It wasn't in the public interest. So thus, it's entirely illegal. Entirely. That was in the interest of the bar. And nobody can argue that. Established standard for ethical conduct. It's established standards, but if they're not doing any of this, and you don't know that they're supposed to do this because you're not reading this. The code is intended to guide and assist judges in maintaining highest standards of judicial and personal conduct. To provide a basis for regulating their conduct through the Illinois Judicial Inquiry Board. Remember, this is based on the ABA codes, okay? Violations may occur even if a judge's distribution or communication is restricted to family and friends is not accessible to the public. Judges must carefully monitor social media accounts to ensure that no communication can be reasonably interpreted as suggesting a bias or prejudice, an ex parte communication, and misuse of judicial powers, prestige, a violation of restrictions, charitable, financial, and political activities, comment on pending or impending case, basis for disqualification, or the absence of judicial independence, partiality, integrity, or competence. All right. Because it's 4 canons. Okay, terminology. You're going to want to read the whole thing. I'm just trying to do this as quick as possible, okay? Let's go down. Canon 1. A judge shall uphold and promote the independence, integrity, and impartiality of the judiciary and avoid the impropriety and the appearance or impropriety of all judges' activities, comments. Independent and honorable judiciary is especially for creating, preserving public trust. People look up the public trust doctrine. The courts are included in the public trust doctrine, just not, the water and the land and the air, but also the courts, medical. Well, look up the public trust doctrine, people. I mean, especially if you're an eco nut, you just want what the public trust says is supposed to legally happen. Compliance with the law. A judge shall comply with the law, including the codes. and the rules are laws too. You know, it'll tell you in the preamble all applicable, and the rules, the codes, and all other applicable laws. And these are the laws in a court of law. Rule 1.2, promoting confidence in the judiciary. A judge shall act at all times in a manner that promotes public confidence in the independence, integrity, and impartiality of the judiciary, and shall avoid impropriety and appearance of propriety. And remember, that's in personal and personal life. Okay? Public confidence in the judiciary. These are just comments, but I mean, you can use that too. Judge shall expect to be the subject of public scrutiny that may be viewed as burdensome if applied to other citizens, and must accept the restrictions imposed by the code. Okay. A judge should participate in activities that promote ethical conduct among judges and lawyers, support professionalism. Oh, okay. Actual improprieties include violations of the law, court rules. Court rules are the codes, the Code of Judicial Conduct and the Rules of Professional Conduct, or provisions of the code. This tests the appearance of impropriety, whether or not. Okay, judge should initiate, participate, and avoiding misuse of prestige of judicial office. A judge shall not misuse the prestige of judicial office to advance the personal or economic interests of the judge or allow others to do so. Canon 2, judge shall perform the duties of a judicial office impartially, competently, and diligently. So even the judges are required to bring up this quick and speedy trial thing, okay? Because remember, not only they're supposed to enforce, but they are legally have to abide by the rules of professional conduct. And the rules of professional conduct requires them to be diligent, expediting litigation, you know, there's so many things they're supposed to do, but they're not doing if you read the rules of professional conduct. And I just went over it briefly, which I'm trying to do as fast as possible, because TikTok only allows 1 hour. The other ones too, some of them only 30 seconds or so, but giving preference to the duties of judicial office. The duties of judicial office prescribed by law shall take the precedence over all of a judge's personal and extrajudicial activities. So, you know, his job comes first. You know, he's like on call. I hated that back in the 80s, being on call. Impartiality and fairness. A judge should uphold the law and shall perform all duties of judicial office fairly and impartially. Okay, how is them not reporting your lawyer in the opposing party, you know, for violating your constitutional right to effective assistance of counsel? I mean, he's supposed to report that. That's misconduct. You know, so that's why in that one video that was saying that he played favoritism, you know, was for the public defender and the state's attorney. The judge, yeah, he did. And the kid proved it. To ensure partiality and fairness, all parties, a judge must be objective and open-minded. Although the judge comes in a bench with a unique background and personal philosophy, it just must interpret and apply the law without regard to whether a judge approves or disapproves of the law in question. Okay? A lot of people don't know that. Judges will make shit up. That's why there should be cameras in there so we can watch. That's why they don't want cameras, and they don't want everybody witnessing everybody breaking these laws on a daily basis. I had somebody tell me he's been dealing with court for 30 years and he don't know of any crooked lawyers or judges. Well, if nobody's abiding by the rules and the codes, nobody's telling you these are their legal obligations to you and the public in general. Come on now. Rule 2.3, bias, prejudice, and harassment. A judge shall perform the duties of judicial office, including administration of duties, without bias or prejudice. I was telling John Q. Public about that, and the judge is showing a whole lot of bias in there. So you bring the rules or the codes with you. Hey, what does this say? It's your job title. I mean, your job description. You're not doing that. You're literally required to report yourself to the proper authorities. Find yourself. I mean, you're not reporting yourself in contempt of the very court you preside over. You're not reporting yourself thus far is in contempt of the very contempt you preside over. And it's multiple counts of attempt because you did it repeatedly. Not reporting my lawyers. That's contempt of the very court you preside over. I'm just, throwing a few ideas out there. I'm sorry. See, some people tell me maybe that's why I got so many threats. I talk to people. But I got a lot of threats from lawyers, call me a smartass. But people didn't know I was, this is legal talk. You hear me talking, it's legal talk. And this is legal talk. This is the law. People tell me, oh, I don't understand. You try reading it. I'm telling you, you could learn anything if you want to. I've taught so many people this, and all I did was encourage them to read. And I guess using my sarcastic attitude helped a little bit. Okay, judge shall not in the performance of judicial duties by words or conduct manifest bias or prejudice or engage harassment, including that but not limited to bias, prejudice, harassment based upon race, sex, gender identity, religion, national origin, ethnicity, pregnancy, disability, age, sexual orientation, marital status, socioeconomic status, or political affiliation, and shall not permit court staff or court officials or other subjects of the judge's direction or control to do so. Proceedings before the court shall be conducted without manifesting bias or prejudice or engaging in harassment based upon attitudes including but not limited to race, sex, gender, identity, religion, national origin, ethnicity, pregnancy, disability, sexual orientation, marital status, economic status, or political affiliation. So that's basically apolitical. A judge shall not retaliate against those who report violations. Last time I reported with the judicial inquiry, well, it wasn't the last time, but a very long time ago I reported the ARDC, the judicial inquiry. I sent reports, and the police gave me a visit. People. I was alone there, the only one I knew or I could trust, any real family I had, was my dad. I didn't want him getting caught up in what I knew was going to come my way. And then they told me about my dad, and I got to worry about him, my mom, the family, whole family. Examples of manifestations of bias, prejudice, include but not limited to epithets, slurs, demeaning nicknames, negative stereotyping, attempted humor based upon stereotypes. I've had a few judges do that to me. The few times I went to traffic court, the judges did their best to demean me, humiliate me, make jokes about me, and they threw out the tickets every time. Judge must avoid conduct that may reasonably be perceived as prejudice or bias. Harassment is verbal, nonverbal, or physical conduct that degenerates or shows hostility or aversion towards a person based on characteristics or classes identified in paragraphs B and C. Harassment based on sex includes but not limited to sexual advances, requests for sexual behaviors, or other verbal, physical contact. I've seen a couple of judges finally lose their job because they're sexually harassing their staff. Retaliation. A lot of people are experiencing retaliation, but there's over 350 million of you. Can't get us all. External influences on judicial conduct. A judge shall not be swayed by public clamor or fear of criticism. A judge shall not permit family, social, political, or financial or other interests or relationships to influence the judge's judicial conduct or judgment. The judge shall not convey or permit others to convey the impression that any person or organization is in a position to influence the judge. Competence, diligent, cooperation. Is he diligent? He's supposed to make sure everything gets through his courts quick and fast to hurry, especially to those poor folks, because, the court is not supposed to be a burden on it's part of the public trust. These are public servants. All lawyers and judges are public servants. All lawyers are. In the preamble, it says that all lawyers do what's in the public interest and maintain the public trust. And the public trust is the judicial system. And make sure all laws apply equally. Look, violating the rule of law. Penalties are for violating the rule of law. I did a video on that. There's some heavy penalties, I'm telling you. So, if they're not treating you as equals, well, that's violating the rule of law. So you can hit them all up with violating the rule of law, violating the letter of the law, because they'll tell you this don't mean what you think it means. Look up penalties for violating the letter of law. You're gonna before they even speak. A lot of people, I get that side eye from lawyers before, trying to tell their clients, well, see, you don't understand. With lawyers, I says. Their lawyers are devoid of the letter of the law. Excuse me? Yeah, what you're about to say is devoid of the letter of the law. And then I get this side. I say, what the penalties are for, violating the letter of the law? And then they walk away. People say, what's the letter of the law? I said, all this, what you see is what you get. Word for word to the letter. That's the letter of the law. So we all see and hear the same thing. That's the spirit of the law. Okay, the right to be heard is an essential component of fair and impartial system of justice. Responsibility to decide. Decorum, demeanor, communications with jurors. Ex parte communications. The judge shall not initiate, permit, or consider ex parte communications or consider other communications made to the judge outside the presence of parties or lawyers concerning a pending or impending matter, except as follows. I was talking to John Q. Public a couple weeks ago. He was complaining about all this ex parte communications. I said, well, it's not allowed. It's against the law. Judicial statements on pending and impending cases shall not make any public statement. Rules and restrictions, disqualification. There's a lot of stuff that you're going to see that doesn't happen once you read this. Supervisory duties, administrative appointing and hiring, responding to judicial and lawyer misconduct. A judge knowing that another judge has committed a violation of the code that raises a substantial question regarding the judge's honesty, trustworthiness, or fitness as a judge in other respects shall inform the Illinois Judicial Inquiry Board. So it's open season. If a judge just knows of another judge or any lawyers, violating rules or codes, it's their legal responsibility to report them. And that's to the Judicial Inquiry Board, Attorney Registration Disciplinary Commission, ethics committees, because those are ethics violations as well. Okay, but they don't do that. That's why, lawyers always laugh. They could do what they want. Nothing's going to happen to them. It's easier to get a judge and lawyer to turn, or a cop to turn, cops to turn on each other to get lawyers and judges. They're all working together to not make sure this doesn't. I'm not saying they make sure, just they don't care. Judge knowing another judge has committed a violation of the code that does not raise a substantial question regarding honesty, trustworthiness, or fitness of a judge shall take the appropriate action. Judge knowing a lawyer has committed a violation of the Illinois Rules of Professional Conduct that does not raise a substantial question regarding his honesty, trustworthiness, or fitness, the lawyer shall take appropriate action. Okay, so reporting misconduct is mandatory. It doesn't say in here failure to report is misconduct, but it's a rule. To report, you have to report. Misconduct is violating any of the rules. So reporting misconduct is misconduct, or failure to report. Judge shall conduct the judge's personal extrajudicial activities to minimize the risk of conflict with the obligations of the judicial office. Okay, I just wanted to get to the one where, it's mandatory, the apolitical thing. When I first read this, it kind of absorbed it to self-imposed ethics. I figured if I'm ever going to judge somebody, I'm going to do it proper. All legal-like. The use of non-public information. Judge shall not intentionally disclose or use non-public information acquired in judicial capacity for any purpose unrelated to the judge's judicial duties. Affiliation with discriminatory organizations. The judge shall not hold membership in any organization that practices hideous discrimination based on sex, race, and gender identity, religion, national origin, ethnicity, or sexual orientation. The LGBT community. Judge shall not discriminate against or be in an organization and not even give the appearance. Remember, it says in personal and professional life, not to even appear. Okay. Well, there's a lot of appearing out there, you know what I'm saying, though, right? Okay, but I'm gonna have to cut this short because it only allows an hour. I don't know how long this has been running. I forgot to set my timer. You're gonna need a lot more prisons, bigger prisons. I don't know how many judges and lawyers are out there. And I can't tell you they're all not doing this. All I can tell you is this is how it's supposed to start. If all this didn't happen in the very beginning, if your lawyer didn't discuss this with you, or at least tell you, hey, look it up, it's on the net. Services an arbitrator or mediator. Judge shall not act as an arbitrator or mediator or perform other judicial functions apart from judge's official duties unless expressly authorized by law. I've seen a judge do that one time, and I questioned that. I got escorted out of the building, federal court. I was always curious. I was always curious when I was young. And I couldn't go to law school, but there's courts everywhere. I go downtown, people will go, oh, downtown. For what? Never mind. Just go. I went a lot of places by myself. I didn't have a lot of friends, but everywhere I went, there was somebody there. And I used to go to a lot of the courts just to watch, listen, see how things work or didn't work. lot of stuff here, but I'm going to cut this short. All right. Reporting requirements. A judge shall file annually with the Clerk of Illinois a verified written statement of economic interests. The contents and filing deadline for the statement shall be specified by administrative order of this court. Okay, people, remember the basic obligations of public service say that all public servants are to consider themselves public property of the people, servants of the people. Read the basic obligations of public service. This is kind of like a slight direction towards that. That was written, I forgot, around the same time the Constitution. Okay. Statement of economic interest required by Illinois Code of Judicial Conduct. A lot of times people tell me they can't find something or there's something missing, or they not see, but they're breaking the law. Okay, but somewhere in here it says you got to be apolitical. All their citizens must be apolitical. All right, but like I said, remember the model rules in the ABA, they can be enhanced, strengthened. Get some prenup guys in there and prenup the hell out of that. Legally, there's not supposed to be any there's no such thing as legal loopholes. There's just the open doors. Intentional. Legal loopholes are intentional. Interest of the bar, not in the public interest. All right, people, this is where deprivation of rights start. You can cite the judge, the opposing party, and your attorney for deprivation of rights. There's penalties for that. And then conclude that as a conspiracy to deprive rights under the color of law, which is penalties for that. All right, not that I'm bored, which I'm just trying to make this as short as possible. I don't know the average attention span. Okay, and some people, I can talk for hours and hours, days, weeks, and I put people to sleep. And I don't want to do that with you, all right? Nothing but love and peace for you. Right? May your Creator always be with you and rain many blessings in each and every day. Let this be not the first, if not the first, definitely not the last, all right? Knowledge is power. Power is wealth. And you can also create some because, if you look up where to file for conspiracy against rights, legislative government agencies, FBI, DOJ, and they will sue on your behalf. So says their website. There's other government agencies that'll help you too. And so you'll want to make a report for deprivation of rights, a conspiracy to deprive rights under the color of law. Violating your right to rule of law. There's penalties for violating the rule of law. I mean, seriously. There's so many laws they break to make you look guilty no matter what court you're in. You see in there that I mentioned about this, they can't discriminate against age. You know how many kids out there are getting locked up without due process, without the right to a lawyer? They tell them, here, sign this, and it's over. Next thing you know, the kids are sitting in jail, and they don't know why they're there. I was watching it on TV. I said, I don't know, they just signed this, and, hey, aren't you supposed to get a lawyer? Hey, did you ever watch SVU? And they always say you have a right to a lawyer. Don't we have a right to a lawyer? But then they say, oh, the kids signed a waiver. They waived their rights to an attorney. What? Did anybody... But I'm telling you, no, that's discrimination, and age, just because somebody old doesn't mean they can't think for themselves. I tried to help a couple keep mom or dad with them. I don't know, but I was telling them about the law. And somebody in the family wanted to take them so they can, I don't know, do something, make some money out of it. And so I went over some of these laws with them, and they went after Grandpappy because he was old and senile, and I said, no, he's not. They have to prove that. And the only way they can prove that is get him in court. And I says, and you can suggest, a motion to compel to where you can have them come and state their case, and then you have Pappy coming in and you, question him, and you say he's competent. They said, yeah, well, you can do that in a deposition. And then issue that to the court, and then there'll be no probable cause to proceed because you proved old Pappy can think for himself. I don't know what happened. They never contacted me, but, a lot of people I helped never get back to me. And I don't mind. Hopefully, it ended on a good note. Okay, but this is a conspiracy against rights under the cloud of law, brought to you by Legal Reform. Nothing but peace and love for you, all right? May your Creator always be with you. May always rain many blessings in each and every day. I wish you a long life and good health. Stay strong, get strong, keep strong. Open your eyes and open your mind. Knowledge is wealth. Get rich, baby. Have a good night.